And we are live. Thank you, everyone, for joining back-to-back conversations about the breaking news. This is breaking news that warrants back-to-back coverage in the James Comey case. Just one of the most lacerating rulings that I have read has ordered the disclosure of the grand jury materials to James Comey defense, but along the way has really torn at the foundations of the case against James Comey. Some of you may have seen my previous chat with Allison Gill. I am here today with Mitch Epner, my friend, a former federal prosecutor from the District of New Jersey, who could really help hash out some of the consequences of the things that were revealed today. One for Lindsey Halligan, for the Department of Justice, for the Trump administration, and also for the person who ratified what Lindsey Halligan did in that grand jury room not once, but twice, Attorney General Pam Bondi. Thank you very much, Mitch, for joining.
Well, thank you for having me. This is really an honor to be on with you. You've been doing amazing work with All Rise News.
Thank you so much, Mitch. That means a lot. We'll get right into it. For folks who did not see the news earlier today, I'm going to read the first paragraph of the ruling by U.S. Magistrate Judge William Fitzpatrick ordering the disclosure of the grand jury material. It reads, quote, "For the reasons set forth below, the court finds the record in this case requires the full disclosure of grand jury materials. In so finding, the court recognizes that this is an extraordinary remedy, but given the factually based challenges the defense has raised to the government's conduct and the prospect that government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary to fully protect the rights of the accused." Why don't we start out with what Judge Fitzpatrick describes as the two fundamental misstatements of law. And I can't imagine a more fundamental misstatement of law. It appears that we don't know the exact statements, but it appears that Halligan instructed the grand jury incorrectly about who bears the burden of proof, with statement of law number one. Number two, she suggested to them that if they weren't persuaded to find probable cause based on the evidence that she presented, that they could assume the government has more evidence, better evidence that they could bring at trial. Is that your reading of this ruling?
It is my reading of this ruling, and if it's okay with you, I'm going to unpack what's wrong with both of them.
Right, of course. Please do.
So anyone who has been trained by the Department of Justice on how to be a prosecutor, or frankly, anybody who didn't sleep through criminal law during law school, understands that the fundamental rule under the Fifth Amendment is that the defense has no burden of proof, and you can never comment on a defendant's failure to take the stand. That is fundamental, and it appears, notwithstanding the redactions, that Halligan basically said to the grand jurors who were questioning her pointedly, according to this opinion, about what was going on, well, if it goes to trial, when it goes to trial, Comey will have to explain what was going on. That's not the law. I mean, that's just fundamentally not the law. In the words of Tom Cruise in A Few Good Men, she must have been out sick on the day they taught law in law school. So then the second thing is this idea that comes across in context that she told the grand jurors who were, again, hostile, that if they didn't like the evidence, that they should believe her. There was more and better evidence out there. And that turns the attorney, who is not a witness, into a witness. And it is vouching for your case. And vouching for a case is a great way to get a prosecution in front of a trial jury overturned. These are fundamental mistakes that a person who is appointed as U.S. attorney has never made before, in my understanding, and I've been at this for over 30 years and been paying attention to what occurred beforehand. But then again, Lindsey Halligan, insurance lawyer until 3 weeks ago.
Right. It reminds me of Groucho Marx joke that those are my principles. If you don't like them, I've got others. You don't like the evidence. You can assume I've got better one that I can bring about later. So let's talk about some of the other, because that wasn't all. It wasn't just that she instructed them badly on fundamental points of law. She also, according to this ruling, that may have violated Comey's Fourth Amendment rights with the search. Can you go into that? And what are the consequences about those possible Fourth Amendment violations beyond the survival of this case?
Well, Adam, I'm going to have to be a little bit grading you down here. It's not just that she may have violated his Fourth Amendment rights, she may have
Mhm.
also violated his Sixth Amendment rights to counsel, because the bad search that is speculated about in this opinion under the Fourth Amendment trespassed apparently onto attorney-client communications, which violates the Sixth Amendment. So I'm going to start with the Sixth Amendment because um, the remedy for that is much broader. Fourth Amendment we'll get to in a moment, but Sixth Amendment, if you trespass on attorney-client communications, you have to be able to prove that everything that was done was untainted by those violations of Sixth Amendment attorney-client communications, meaning B, everybody who was potentially tainted is disqualified from working on the case. That's the reason to have what they call a taint team. And you can cue our friend Ken White about puns one can make about the taint team, which is why the DOJ now tends to call it like a disclosure team or a prophylactic team, you know. But this is a huge problem. Um, and then the Fourth Amendment problem is multi-level. So I'm going to walk through this stepwise. Daniel Richman, attorney for James Comey, was himself investigated by the Trump first administration about leaks of classified information. That is when they went and got a search warrant for Daniel Richman's documents that had to do with that particular potential crime. And a search warrant has to describe with particularity the underlying crime that you are trying to find evidence about. And if what is obtained is broader than what you're searching for, you have to give it back. You can't preserve it. They also, back in the first Trump administration, when they were going through these materials, they relied upon Richmond, who had his own attorney, um, as the only person who they were working with regard to a taint team. They did not inform Comey that this was going on, and they were not able to get um, so Comey had no part in this process. That's a problem. They apparently kept this material for years after that first investigation was closed. It was closed during the Biden administration. Apparently, nobody got rid of it. They kept far. They kept far more than what would have been investigatory of the thing that was called for in the 2017 warrant. That's a problem. Then in 2025, when they were racing the statute of limitations to try to bring a charge against James Comey, instead of getting a new search warrant, which would have required a new showing of fresh probable cause, they decided to go back and reinvestigate those materials that they had seized from Richmond. That's a problem. And when they did that, they ran into, surprise, surprise, attorney-client communications between Richmond and Comey because Richmond was Comey's lawyer. And they were alerted to that before the indictment was sought by an FBI agent, and they did nothing about it. In fact, to the contrary, according to the judge's opinion, the FBI agent who ran into the attorney-client communications gave a broad overview, whatever that means, and the judge literally says whatever that means, of what was found as attorney-client communications to Lindsey Halligan. So she is tainted. This thing is a disaster from beginning to end. If you were looking for 50 ways to screw up a prosecution, you don't need to call Paul Simon. You don't need to make a new plan, Stan. This thing is a disaster. It is, in the words of the World War II troops, FUBAR.
I love the Paul Simon reference, by the way. The judge itemizes 11 different findings of fact as to why these grand jury proceedings are troubled. I want to
Oh, we
read
haven't gotten to the biggest one yet.
Right. Go right ahead.
The biggest one is the judge suspects that Halligan is lying about how it is that we went from an original indictment that got no billed on count 1 and a true bill on counts 2 and 3 to the actual piece of paper that got turned into the court that had transformed what had been count 2 into count 1 and had been count 3 into count 2.
Now, if I
And
can just set the stage for you right now, Mitch. I was in Alexandria, Virginia last week. So to catch folks up, one of the revelations of the hearing about Lindsey Halligan's disqualification is that a judge announced for the first time that the grand jury record ended at 4:28 p.m. in the afternoon until the issuance of the indictment at 6:40 p.m., playing cleanup the day after the hearing. And I should note, Lindsey Halligan, sitting at the table, said nothing about that gap during the hearing. Her assistant said nothing about that gap during the hearing. The day after, they claimed it was deliberations. Take it from there, Mitch.
so, first of all, when this came out, I turned to former colleagues from the District of New Jersey, where I was an assistant U.S. attorney from 2001 to 2004. I turned to friends and classmates from law school who served as federal prosecutors around the country. None of us had ever heard of such a thing. Like, another extraordinarily basic rule of grand jury practice is you, if you are an AUSA, or in this case, a United States attorney, and you are in front of the grand jury and you are discussing anything substantive, it's on the record with a court reporter. There was apparently also an audio recording made, and it's not clear to me how much is captured by the audio recording that was not captured by the transcript. But the judge makes it clear, even when you add all of those things together, it is still an absolute mystery how you got from the no bill on count 1, true bill on counts 2 and 3 to the thing that was turned into the district court. And the judge says it would be unprecedented for a a U.S. attorney to have turned into a presiding judge an indictment that was not actually the indictment that was passed upon by the grand jurors.
Right.
And it is, what I read that to mean is, it's possible that they didn't get the foreman of the grand jury to sign the second document. They just literally cut and pasted the signature from document number 1 to document number 2. Um, these are the types of things that, under any other administration, including Trump 1, would have led to A, the immediate dismissal of all the charges, and B, the immediate dismissal of the prosecutors who were involved. I have no great love. In fact, I have tremendous antipathy for Bill Barr. But he would not put up with this sort of fertilizer.
Right. And let's dig a little bit deeper into the ethical implications of that potentially for Lindsey Halligan and Pam Bondi, who ratified her actions before the grand jury, not once, but twice. But first, I want to read a couple of footnotes to the ruling in that very section that you're talking about. One of the footnotes, the judge makes a point of saying, quote, "It is the responsibility of the United States Attorney's Office to record and, if required, transcribe all grand jury proceedings." So she makes clear in one footnote that this gap should not exist if there's anyone speaking between 4:28 p.m. to 6:40 p.m. She also, the
Well,
judge
I think
also,
this is Judge Fitzpatrick is a he.
yes, I'm going back and forth between Halligan and Fitzpatrick. Judge Fitzpatrick also says in footnote 11, if the court is to read the prosecutor's declaration as suggesting there was no contact between any government official and grand jury after 4:28 p.m., then it begs the question of how the then first assistant learned that the grand jury had refused to indict on one count, and how the first assistant knew that the count had been rejected by the grand jury, all before the indictment was returned in open court. So clearly, the judge does not let's just put it as nicely as possible, deeply questions Halligan's account of what happens. Does candor to the tribunal fit anywhere in all this?
Candor to the tribunal is always a duty of any attorney, but when you have ex parte proceedings, such as grand jury proceedings, where there is no defense counsel there isn't even a judge there to supervise them, the ethical obligations of a prosecutor in that circumstance are at their highest. So this is extraordinarily important. It is extraordinarily damning. And as my friend, and I'm going to invoke his name again, Ken White, said today on social media, at a certain level, if you put somebody who is utterly incompetent out there to do something that is beyond their capability, the question of whether it's intentional that they screw up or an accident becomes not important. If you asked an auto mechanic to perform brain surgery, the fact that they screwed up isn't on the mechanic, it's on the person who put them in that position.
Right. And so, what could happen next? And for folks watching, you might better know Ken White by his nom de plume, Pope hat. You'll find him on social media. And many of you probably already know who Ken White is, prominent First Amendment attorney. What is potentially next here, given the fact that Bondi twice ratified Halligan's actions when she went into that grand jury room for the first time in her life, to answer a question that I saw in the comments here a moment ago. She had claimed that her first assistant, the assistant to the top prosecutor, had informed her that the grand jury had had ended their deliberations with a true bill on two of the three counts. What's next? Potentially, what are the consequences if uh, James Comey's defense builds out the record even further, proves the misconduct that is flagged in this document? What could this mean for Lindsey Halligan and Pam Bondi?
Well, can I answer the prior question, which is what does it mean for the prosecution before we get to the consequences?
Sure. Let's do that first.
So for the prosecution, it as is explicitly said in Judge Fitzpatrick's decision, what is at issue is whether or not this indictment will be dismissed. And if it's dismissed with prejudice. And when you have 11 separate instances of potential prosecutorial misconduct, any one of them could lead to the case being dismissed with prejudice, which would be an ignominious end for the President of the United States um, crusade against James Comey. Um, and there are many other reasons why the case may get dismissed, but this is something extraordinarily powerful that doesn't get to the underlying question of was this a a vindictive prosecution. There are other issues that would require plumbing the motive of Donald Trump. This could get dismissed without getting to any of those questions. So that's thing number one. Do you want me to pause there or move to the?
Why don't you pause there? Because I will note the judge says in his ruling, Judge Fitzpatrick mentions that any of these could be the bases to dismiss one or more counts of this two-count indictment. So he explicitly mentions that. He also explicitly notes, correct me if I'm mistaken, that the evidence that we were speaking about earlier that may include attorney-client communications and may have violated the Fourth and Sixth Amendment rights of Mr. Comey was the heart of the evidence in the grand jury presentation. Is that correct?
Absolutely. You've got that precisely right.
And so this could spell the end of the case of James Comey if Judge Curry from the District of South Carolina, who's presiding over the disqualification proceedings, she could rule before Thanksgiving to dismiss this with prejudice. So any of these bases could dismiss the case well before a trial begins, correct?
Right. And Judge Fitzpatrick is not reporting into the South Carolina judge on this. This is a totally separate thing, reporting into the Eastern District of Virginia judge who's actually presiding on the case.
So let's go to the question after this. If this is dismissed and dismissed with prejudice by either Judge Curry or Judge Fitzpatrick or Judge Nachmanov, what other consequences for the 11 different instances of potential misconduct itemized in this document? What could be the fallout beyond the criminal case against James Comey?
So let me start by saying what ordinarily would have happened. Noting before I say it, I don't think that it's likely in this case because Donald Trump has so perverted the Department of Justice. Within the Department of Justice, there's something called the Office of Professional Responsibility, the OPR. And anytime there is a hearing, let alone a finding of prosecutorial misconduct, OPR would run an investigation and could recommend anything from nothing to remedial continuing legal education to suspension to termination as a prosecutor. And that is, if one of these 11 were found to be under any prior administration, the OPR would recommend termination and would actually, that would lead to the termination of the prosecutor. And that is major. But even beyond that, it would also get referred to the bar of the court where the individual had their law license. Now, it's important to note that there is a difference between the bar that regulates attorney practice in a state, for example, in Florida, where Lindsey Halligan is from, and the Bar Association, which is basically a trade group. The Bar Association doesn't do anything with regard to attorney discipline, but the bar does. And ordinarily, that is something that has judges sitting on it who refer things out to a disciplinary committee, which is either retired judges, sometimes active judges, sometimes eminent practitioners who would make a recommendation. This could lead to the suspension or termination of the law license for Lindsey Halligan. Let's move it up one level to Pam Bondi. With regard to Pam Bondi, because she is the Attorney General, an OPR investigation would, if it existed, would make a recommendation to Pam Bondi herself, who would be the person who is making a decision. There may be procedures in place on how you deal with an OPR investigation when it's the Attorney General herself who's being investigated, but I don't know what they are. The last time that this may have happened would have been John Mitchell during Watergate.
Mm,
Um, and I'm just not familiar with what happened there. But again, this could be referred to the bar of the state of Florida and could lead to suspension or termination of her law license. Now, for her, you'd have to be able to show that she ratified knowingly misconduct. The worst fact for her is that she's now, after ratifying it once and having it called out by the South Carolina judge, hey, you didn't have the whole record in front of you. She said, oh, no, no, no. Now I've reviewed the whole record and everything is ratified. It makes it very hard to say that the problems escaped her notice.
right. And isn't this part of a trajectory we've seen a number of times in Trump world, where after the 2020 election, you had a number of Trump loyalist attorneys go to the mat and take ridiculous legal positions, and there's Rudy Giuliani getting disbarred. There's all of the architects of the strategy to subvert the 2020 presidential election getting disbarred. Is this part of that trajectory?
Well, the difference is that Ken Chesebro it is and was a brilliant attorney. He spent decades as sort of the the research assistant slash colleague of um, Professor Tribe of Harvard Law School. Rudy Giuliani at one time was a brilliant lawyer. Those days have long since passed, but he really was an eminent practitioner at some point. Um, these are not those sorts of legal minds.
And we still, there's this one kind of Chekhov's gun lying there, which is this memo that we heard well before this prosecution initiated, before the indictment became public, that there was a memo of every career prosecutor saying, this is not a case worth pursuing. This is not a case you can prove beyond a reasonable doubt. What happens once that comes to light?
So here, I want people to understand that that memo is not something that was just gratuitously created. When you have a big investigation, and frankly, any sort of case that is opened, the case either closes with a declination memo that goes into the file to explain, here's why we're not bringing charges, or the case, you get a prosecution memo, which leads to approval within the U.S. Attorney's Office or the DOJ to go forward and seek an indictment. So the declination memo was saying, we've done all of the work. We believe that there is not a meritorious prosecution here. And having read the declination memo, the DOJ main justice overrode that, sent the acting U.S. attorney out on a rail and replaced him with Lindsey Halligan, who, when Trump said jump, said how high.
Thank you very much, Mitch, for breaking it down. There's a hearing, of course, this week in Alexandria, Virginia, and it's going to be presided by U.S. Magistrate Judge William Fitzpatrick. What do you think that looks like in the wake of this ruling?
Um, the scene airplane where first it says don't panic and then it says okay go ahead and panic and you have all mayhem breaking loose.
That sounds about right. Well, okay, I'm going to be in Alexandria, Virginia this Wednesday. For folks watching right now, take a moment to subscribe to both Mitch Epner and my Substack. After this conversation ends, I'll post it on the All Rise News website. If you see the little on the top left of your screen, that's the way you can subscribe right now. And I'll be reporting live from the court. See what that airplane style fallout will be. Thank you, as always, Mitch Epner, one of my go-to legal analysts to really break it down with the former prosecutor's perspective and a close friend. Thank you for being here today.
Thank you for having me.
Okay. Uh, those watching, look out for if you signed in late, look for the full interview on All Rise News, posted along with my conversation a little earlier on the breaking news with Allison Gill. Thank you for watching.